Hey, everybody, it's your girl, Geneviéve Jones-Wright, and I am so excited to be here speaking with you all about AB679. Let me tell you, it is a game changer. We've all heard of in custody informants, or maybe you've heard of jailhouse snitches, as we say on the streets. These are people who are in custody in some sort of penal institution, like a jail or correctional facility, who give information to the district attorney or other law enforcement agencies about someone else. The information that they provide is helpful to the law enforcement agency in getting a conviction of that person who is a defendant in a case. We know the problems with in custody informants because, let's think about it, most times they are incentivized by the district attorney, for example, to provide that information. That means that they are providing information about someone else with the incentive of getting some sort of kickback or benefit for themselves. The normal things that we see are reductions of their own sentences or even absolute immunity, meaning that even for crimes they are guilty of, they will never be prosecuted for. And I've seen this a lot right here in San Diego. Sometimes these folks, some of whom make a career out of being in custody informants or jailhouse snitches, get rewarded with relocation out of state for them and their family, with houses bought for them. Do you see the problem? Do you see where I'm going and what AB 679 will get rid of? Yeah. That system of incentivizing folks to lie and make up things about people so that they can get some sort of benefit. This happens all the time. And even though if you were a juror in a criminal case that involved a jailhouse snitch, information that was got by this person or direct testimony from this person, you would get a jury instruction that says you are to consider the fact that this person who testified got some sort of benefit. You heard that they got X, Y, and Z. Now you are to consider the weight of that information. How do you think it influenced or affected their testimony? Well, you may be thinking to yourself that you would weigh that very heavily. In reality, jurors don't. All they see and all they hear is that one criminal is saying that the defendant is another criminal. And there's only one person that's in front of you to judge, and it is a criminal. And so most times jurors convict on that testimony, because even though the law says that in custody informant testimony must be corroborated, it is a very, very low bar. The connection between the defendant and the commission of the crime, for example, can be very slight. And so in custody informant testimony comes in most of the time. So what would AB 679 do? Well, it would completely get in custody informant testimony off the table. I mean, I'm so excited I can't even get it out of my mouth. Can you imagine if this bill passes? That means that if it is testimony or information gathered or gotten by a jailhouse snitch, it's not even on the table for the jury to consider at all. You never hear about it as a juror. And it changes what in custody means. So no longer does the person who's the jailhouse snitch actually have to be in jail. All they have to be is under the control or dominion of a law enforcement agency or believed to be in custody. Yeah, that's another trick of law enforcement. They put people inside of the jail in order to extract information to convict someone. So as you can see, AB 679 is a complete game changer and we need it. So I need you all to join me, to join us, to join Team Justice. Contact your state legislators and let them know that we need to pass AB 679. We need it on the books. If they believe in justice, if they believe in fairness, if they believe in a criminal justice system that actually does justice, then they have to support AB 679. There's no other way. This is how we can cut against one of the biggest reasons why we have wrongful convictions and incarcerations in California. Trust me, I know, not just from being a defense attorney for years, but also being a volunteer attorney with the California Innocence Project. I have seen this time and time again. It is time to get rid of in custody informant testimony and information gathering that's used in court against people. Thank you.